Hey folks, Don Rolfe here with Northwest Legal Planning, and today you can probably notice that this live video is going to be a little bit different. I have Shivon with me, a friend of mine, who has agreed to help out to maybe bring a little bit more excitement to these videos. But as always, I'm here to answer some of the most frequently asked questions that I get about estate planning. And if you have your own questions, you can always reach out to me by going to myestateplanmeeting.com and scheduling a complimentary consultation that we can do either on the phone or in person. I prefer in person just because I like to talk to people, and that's one of the reasons I'm very excited to have Shivon here today, because I actually get to interact with another human being while I'm also interacting with you online. So Shivon, if you could just say hi.
Hi.
And basically what we're going to do is Shivon's going to basically role play as a couple of people who have sent in questions to me from Facebook and ask those questions, and I'm going to answer them live. Obviously this isn't legal advice, and that you need to seek out your own counsel and make sure that what we're doing applies to your situation. And then Shivon's also got a couple of questions of her own that she wanted to ask me more generally about estate planning. So Shivon, take it away with the first question.
All right. Question number one. This is from Jenny from Milwaukee. What is the benefit of someone in their 30s starting an estate plan?
Well, the benefit of starting an estate plan in your 30s is that you're not going to wait to start into your 40s and 50s and 60s. And really, we never know when the end is going to come. And someone in their 30s is probably starting to amass some wealth. Maybe not what we would consider to be a really wealthy person. They're probably not Jeff Bezos. If they are, they probably already have an estate plan. But you're starting to amass some wealth, and you may also have started a family. You may have a spouse, you may have some children, and an estate plan covers more than just dispersing your assets after you're gone. It covers healthcare decisions for you while you're alive. It also covers appointing temporary guardians for your children if you and your spouse, or just you, are injured, incapacitated, so that Child Protective Services isn't coming in to take the kids away. There's a plan for where they're going to go and who's going to take care of them, so that once you recover, you can be back in their life. It's also the only place that you can name permanent guardians for after you pass away. So if you happen to die before your kids reach the age of majority, and you haven't named guardians in a will, then it's going to be up to a court to appoint those guardians. And most likely it'll be a loving family member, but it could be the family member that you would like least to be the one raising your children. So it's really important to have that done. Plus, younger people are often a little less organized in their financial affairs, and the estate planning process really forces you to gather all of the information that you have about all of your bank accounts, your investments, retirement accounts. Retirement accounts are a big thing. A lot of people don't even realize sometimes that they have an old 401k hanging out there from an old job. Right. It forces you to bring that all together and to understand exactly what your financial and asset world looks like, so that you have a better picture moving forward. And it can also just be a good peace of mind thing to have, especially if you have those kids. Definitely. So Jenny, thanks for the question.
Yeah. All right, our next question is from Robert in Portland, and he said, what steps would you recommend for a young family to take regarding their estate plan when they do not have many assets?
Well, this question kind of overlaps the one that we just had before, but in a completely different way. If you don't have any assets, that does not mean you do not need an estate plan. All of those things that we just talked about can be put into place. The healthcare, the guardians, making decisions about who's going to get your things, even if you don't have any right now. Those decisions can be all made now before you have any assets, and as you accumulate assets in the future, those decisions will still hold for assets that you get in the future. Now, what steps do you need to take? The number one step is, if you're an individual, you just need to make up your mind that you need to do it and start looking around for someone that you're comfortable working with. If you have a spouse, it really is a good time to sit down, talk to that spouse, make sure you're both on the same page, and I would suggest that both of you look for the person that you want to work with. When I work with couples, I will only work with both of them together. I do not work with what I call lone rangers. And if you come in to work with me or another estate planning attorney and you have and you're married, you're going to have to sign a conflict waiver so that person can represent both of you. But it just, unless there's contention, prenups, and so on and so forth, it just doesn't make sense to have separate counsel most of the time. But just be aware that once you sign that waiver, anything you tell your attorney husband, that attorney is going to tell your wife and vice versa. But really, that's the first thing that you need to do to get started. And then pick out that person and go meet with them. You can meet with me for free. I know a lot of other estate planning attorneys offer complimentary consultations just to kind of understand what the process is all about. Mm-hmm. And briefly, the process really is, it's about a 4-meeting process. There's a get to know you meeting, then we sit down and we have a design meeting, then we'll sit down after all of your documents are drafted and you've approved them and sign those documents, and then we'll meet one more time to deliver those documents to you. And if you have put together a trust-based estate plan, we're going to also talk about funding that trust. Yeah, does that sound good?
Yeah, it does. That sounds good.
Excellent. I noticed we had a couple of people pop on, but I didn't catch their names. I'm sorry about that.
All right. So the question I have for you is, when it comes to estate planning, is being married an asset or a liability in Oregon?
Well, as long as you're happily married, in any state that you're in that has an estate tax, it's going to be a benefit to be married.
Okay.
And the downside is, in order to take advantage of that benefit, you have to be the second one to die, or one of you has to die. So when the first spouse passes away, they can leave everything to the surviving spouse without incurring any estate tax liability. Okay. There is a 100% estate tax exemption, at least in Oregon and at the federal level, and I'm quite certain in every state that you can leave your spouse as much money as you want, and there is no estate tax implication. So I know that he just got divorced. Well, instead of using Bezos, let's use Bill Gates. I mean, Bill Gates has $100 billion, right? Mm-hmm. And he could essentially leave all of that to Belinda Gates, estate tax free. Obviously, they're using some more complicated estate planning strategies with foundations and large gifts and endowments and so forth in order to reduce their estate tax liability. Mm-hmm. But if they wanted to do it in a very simple way, they could just plan on Bill dying first, and he could leave everything to his wife, and it would be estate tax free. So it is a benefit to be married. If you're in a long-term committed relationship and you're not married, you're going to lose that benefit when the first spouse dies. So you're going to have to do some different strategies for reducing the estate tax if that's going to be part of your estate. And in Oregon, the estate tax comes in very early. It comes in at just $1 million, and it doesn't take much to get to that $1 million threshold. So if you have assets that total over $1 million in your name, including life insurance policies that you own, then the Oregon estate tax is going to kick in. So, wow. Good question. I like that.
So my second question is, why do you think so many people put off estate planning?
Well, most people think of estate planning as planning for my death, right?
Yeah, right.
I'm going to sit down with somebody and talk about my demise. And I think that's really why a lot of people put it off, is because no one wants to think about their finality. And really, a lot of the people that I work with are older individuals, 65 plus. I actually have had clients that were in their 90s and we were doing their first estate plan, because I don't know why they put it off so long, but they had grown children that were in their 60s. But I really think that that's the reason that people put it off, and it's not an immediate need. Mm-hmm. It's not urgent, but it becomes urgent the second that you need it. If it's not in place, then there is no do-over, there is no going back. There's no way to create an estate plan after you've passed away. There's no way to put together an advance directive once you become incapacitated. If you're unconscious in the hospital, there is no way for you then to put together an advance directive to give directions as to whether you would want life support or tube feeding, or what kind of pain management you want. There's no way to appoint a healthcare representative. So while it's not urgent, while you're living your life day to day, it really is something that's very important because the need for it springs up instantly. People have heart attacks, people are in car accidents. So why they put it off? Because I don't think people are comfortable talking about death. Are you comfortable talking about death?
No, I'm not. I'm not. And for my own family, it's something that we haven't done yet. We do not have an estate plan.
Well, we're going to fix that.
Yeah, that would be
it's
great.
an absolute necessity. Because you have children, right?
I do.
And you know, that's one of the reasons that I got into estate planning was I was thinking about starting a family, and I was looking at, you know, being an analytical type person, having studied engineering and then going to law school, and I analyzed problems, right? I was like, well, what are the things that I'm going to have to do as a dad? And I figured out estate planning was one of them, and then I started looking at what is estate planning all about, and I was actually very excited to start practicing estate planning because I was actually helping people right now, putting their minds at ease and making sure that there was something in place that was going to help if there was a problem in the future, rather than my old life being a litigator, which I know Shivon circles in that world of litigation a little bit, and it's really cleaning up messes after they've already happened, and it's just not fun most of the time. It can be, but it's much more rewarding for me now being an estate planning attorney. But that's how I got my start, and it was my wife and I were planning on having children, and you know, trying to be the responsible dad, and figuring out the things that I would need to do in order to be a good one.
Right.
Anyway, well, I think that's all of the questions that we have today. I really want to thank you, Shivon, for helping me out here, and I hope this was a little bit more entertaining for you folks. And again, if you have questions, you can send them to me on Facebook. I think Shivon might be open to doing this again.
Definitely.
And if you have a question that you'd like me to answer personally, or it's a little bit more involved, please do go to myestateplanmeeting.com, and you can schedule a half-hour complimentary consultation either on the phone or in person, where I can answer those questions and talk to you about your options for putting together your own estate plan. So until next time, I am Don Rolfe, and this is Shivon, and we'll see you later.
All right. Bye.
Bye.